Sometimes bar examinations are based on what you might call innocuous provisions. Yung mga provision na hindi natin masyadong pinagpapapansin. So, it might help you to remember the provisions of Article 716, which speaks about swarms of bees. If you happen to be engaged in the production of honey, so meron kang mga bees, if they transfer to the neighboring estate, you have the right to pursue them. Medyo mahirap ma-imagine. Hahabulin mo yung bees. Ordinarily, ikaw ang hinahabol ng bees. Diba? But under Article 716, the law gives you the right to pursue them. But you have only 2 days. If you do not pursue them for 2 consecutive days, then they would belong to the owner of the land to which they have transferred. With respect to domesticated animals, you have a little bit longer period, 20 days. If you don't claim your animals, domesticated animals, within this 20-day period, they would belong to the one who has caught them. Please take note that Article 716 applies only to domesticated animals. There is a difference between domesticated and domestic animals. In the case of domestic animals, dogs, for example, or cats, they are not subject to that provision. In other words, kung meron kang aso, even if they have been in the possession of somebody else for more than 20 days, you can still claim your dog back. Unless, of course, you have already abandoned your dog. Occupation would not be possible because they still have an owner. All right. And then, you also remember the special rule for pigeons and fish. If they transfer to another estate, provided they have not been lured by some artifice or fraud, they would belong to the owner of that other estate. Kung meron kang property, tapos dumating ang another undoy, yung nearby fish pond owner, maraming bangos, nagbaha. Yung mga bangos, nagpunta do sa property mo. Sa'yo na yun. Praise the Lord. All right. Under the provisions of Article 717. And then, the other important thing I want you to remember is the rule of finders keepers under Article 719 and 720 of the Civil Code. If you find movable property, which is not a treasure, and you know who the owner or lawful possessor is, you are obligated to return it. So what's the rule? You're supposed to return it to the lawful owner or possessor. And in this connection, you have even a provision in the Revised Penal Code. Article 308 of the Revised Penal Code. You are guilty of theft if you do not give that property to the lawful possessor or to the proper authorities under Article 308. So, what is the requirement under Article 719? May nakita kang personal property, hindi mo alam kung sinong may-ari or who is the lawful possessor. You are supposed to deliver it to the local mayor. Pagbigay kay mayor, hindi ibig sabihin kay mayor na yon. The mayor is obliged under this provision to publish the finding of that movable for 2 consecutive weeks in any way he deems best. So, pwedeng mag-post ng notices sa bulletin board, halimbawa sa munisipyo or sa city hall, in any way that the mayor deems best for 2 consecutive weeks. Now, if the property is of such nature that it would deteriorate or it would necessitate incurring expenses just to keep it, which would diminish the value, the law allows the sale of the property after 8 days from the publication of the notice. Kung ang nakitang property is 1 galon na ice cream, syempre hindi naman tatagal yan. You cannot even wait for 8 days. 6 months from publication, that's the period given to the owner to appear and to claim it. If it does not appear, nung 6 months after publication, then the property would belong to the finder. If the owner, however, appears, may obligatory reward 10% of the value of the property. The law requires him to give a reward to the finder. Last point on the various modes of acquiring ownership. Yung sa intellectual creation, we need not bother with the details, yung mga copyrights, etc. You'll take that up in another subject. Tanda lang yung the rule with respect to letters under Article 723. Who has ownership? The addressee. The person to whom these letters were addressed and delivered. Sila may-ari. But they cannot just be published without the consent of the writer of the letter or his heirs. Of course, The courts may authorize the publication if the same is necessary for the public good or in the interest of justice. Pwede, but there must be court authorization. The addressee or the recipient of the letter cannot just publish them. I think that affords a little degree of protection to people who are fond of writing love notes and love letters. Hindi pwedeng i-publish yan. Hindi siya pwedeng mabuking without his consent or at least the consent of his heirs.